waiting room. And Mr. Chapman, the defendant, is here as well, representing himself.
This is case 210540 LT, David and Martha Brown versus James F. Chapman and all occupants. This matter is being recorded and is being streamed live over YouTube. Mr. DePietro, I note your appearance this afternoon, as well as Mr. Brown and Mr. Chapman. This is the first hearing in this landlord-tenant matter, and consistent with the applicable administrative order, which is 2020-17, I want to advise the defendant that he has a right to counsel, that the Michigan Department of Health and Human Services, the local coordinated entry agency, or the Federal Help for Homeless Veterans Program may be able to assist parties with payment of some or all of the rent that may be due. The defendant does not need a judgment to receive assistance from MDHHS or the local CEA. The summons and complaint from the court are sufficient. And that there's a possibility that a conditional dismissal pursuant to MCR 2.602, if approved by the parties, could be entered today. Having put that information on the record, Mr. DePietro, I also wanted to advise you that I received 2 phone calls from Mr. Chapman, one on February 12th at 6:52 p.m. and one on February 15th at 4:56 p.m. I did not answer those calls and I did not receive any message from Mr. Chapman, but I wanted to at least advise you of that development in as much as we had a hearing scheduled for today.
Thank you, Your Honor. Acknowledged.
So those things having been said, what is the desire of the parties this afternoon, Mr. DePietro?
But I'm asking the court to enter judgment on behalf of the plaintiffs against the defendant. This case involves a non-residential commercial unit that the defendant has been using as a residential unit in violation of the Belleville City Codes, probably the Wayne County Health Department regulations as well. He has previously agreed to vacate the premises on December 15th, but had a change of heart, as a result of which we had to start this suit. The problem, Your Honor, in addition to the fact that he's violating the city ordinances, is that he has engaged in some self-help with regard to what he perceives as his need for protection from a tenant to the adjacent business. These guys, in fact, kind of share the parking lot and driveway together. In any event, he has taken the doors and cut the hinges off of the access door to the premises, which is a garage, basically, Judge, and welded the door shut so that he could limit access to those premises, ostensibly because he believes that the other tenant is stealing stuff from him. The landlord has been barred possession. The tenant has removed and or neutralized the security cams, so we have no idea what's going on inside the place. And the police have been to the premises, and I may be wrong on this, but I think it was 4 times. I know I have spoken personally to the chief of police about all of the carryings on of Mr. Chapman at that location. And I know it's cold out, but we got to get rid of him, Judge. And I haven't received any rebuttal or factual disputes to the allegations made in my complaint that were included in a separate addendum to the complaint. And those allegations, I would submit, Your Honor, at this stage of the game, must be taken as true in a judgment entered for the plaintiff. Thanks, Judge.
Mr. DePietro, our office, the court did in fact receive a written statement from Mr. Chapman on February 11th. If you have not received that, I'll make sure the civil department sends it to you. In that document, Mr. Chapman does in fact request a trial by jury, which this court is not currently doing due to COVID restrictions. He indicates that he does not have the technology to participate fully in the Zoom platform, and he's requesting that that this hearing be conducted in person. And he does contest your statement of facts. But I'm guessing by your argument that you have not received that, so I will make sure the civil department sends it to you.
That's true. That's true, Judge. Has he denied that he's using the premises as a residential unit? Because that seems to be the core kicker right there.
And I understand, Mr. DePietro, and if you brought this matter as a health hazard case, we'd have a different conversation. But in my review of the file, it appears to be essentially a termination of his tenancy. And the administrative order currently in place requires that this pretrial be adjourned for 7 days. So this is not the actual date and time for the argument you made requesting entry of a judgment. But I wanted to find out what the issues were so that we could figure out how soon we could have a hearing in this matter. If Mr. Chapman was going to persist in his request for a jury trial or in-person hearing. I'm happy to accommodate the in-person hearing, but right now we're just not scheduling jury trials because of the limits on the number of people allowed in the building. But Mr. Chapman, was there something you wanted to say on the narrow issue of what we do next?
The narrow issue of what we do next, I would propose that there be a 30-day adjournment until we find out what the governor is going to do about the COVID restrictions, or whether or not we can proceed. Because my argument is based on the Sixth Amendment to the United States Constitution that I'm guaranteed a public trial. And that to me means face-to-face with accusation. I have a number of things for the record. I dispute every factual allegation made by the defendant's attorney. Are you going to swear me in first?
I'm not taking testimony from you, Mr. Chapman. Today is the pretrial, it's the first hearing in this matter.
Well, I dispute all material facts. This is going to show that the other tenant has in fact is going to be tried for a felony against me. For felonious assault with a motor vehicle that happened right here in the parking lot, which resulted in great damages to my property, and that he has been used to spike the door locks. And with or without Mr. Brown's permission, it doesn't matter. I have been prevented from access to the premises by him, through him. And there is also a case pending with Jeffrey Wickham of the Belleville Police Department that has film on him, Mr. Gene Carrier, carrying out about $5,000 or $6,000 worth of pistons and rods from here. And I believe that's a felonious larceny. And until this stuff it needs to run its course. Until then, it'd give me a little more time to thoroughly clean my stuff out of here and out of the parking lot. I can't get anything out of the parking lot because it's been snow plowed in. Believe me, I want to be gone, and I have a place or two elsewhere. As to the allegation of living here, I'd like to point out there's no shower, no toilet, no bathroom facilities. It's impossible to live here, okay? And if they're accusing me of being here all night, well, that's one thing. But according to that, there's no restrictions in the commercial code for being here all night. And I just, I can end with that. I'm good for a 30-day delay on this to find out what develops with filing of the charges against Mr. Carrier for carrying off my engine parts. And Mr. Brown has been in denial about knowing about it. But nevertheless, Jeff Wickham has the film on that. And that is awaiting approval from the Wayne County Prosecutor's Office. It's a very tangled web here, and Attorney DePietro has kept the issue narrow and with unsubstantiated facts. And we can only find this out by a proper jury trial, ma'am, to where the trier of fact understands what's going on and they can render their decision. As far as that goes, I have rendered Mr. Brown a great deal of service in rebuilding his engines, and I believe he's in arrears. So we'll just total up what it's worth to build an engine, and especially the older engines, and we'll go at it from that way. And that too can be presented to a jury. But I'm going to rest. Thank you,
You're not
Your Honor.
resting because there's not argument, Mr. Chapman. As I indicated to Mr. DePietro, this is just a pretrial. The matter will be adjourned for 7 days.
Your Honor, may I address an escrow order?
Your motion for escrow? Please proceed.
We're asking that the court order the sum of $1,000 per month being the fair market value of the commercial property being rented by the defendant, and that it commence on March 1st to give him some time to get up on that cash. And in failing to comply with this court's escrow order, that a judgment of default be entered against him. Further, Judge, we're in continuing violation of the ordinances. Perhaps your order could also include that he not use the premises to sleep in, or as I call it, live in. I stipulate with Mr. Chapman that there is no facilities that would allow a human being to sleep in that property. Thank you, Judge. By
Your
the way,
response.
I'm sorry, Judge. My clients here, does the court ordinarily entertain comment from the client at a pretrial?
Not in a landlord-tenant simple
Certainly.
termination case, I believe this was. Mr. Chapman, your response to the request for escrow.
I'm going to deny that request or not acquiesce. I'm going to request that the court doesn't. There has been no signed agreement between Mr. Brown and I for any amount of money. I'd like this just to go through till the termination. And I think that once we wash our hands of each other and go our separate ways, that all will be well.
If I might just add, this has been the story Mr. Brown has been hearing since October 1st. Thank you, Your Honor.
And Mr. DePietro, on your request for escrow, I did not see anything in your attachments to your complaint that indicates that there have been any rent paid previously or establishing what the rental rate was.
I would agree with that, Judge. That's why I'm asking you to set one, because of my client being in violation of the city ordinance, because Mr. Chapman continues to reside in the premises, harass the tenant next door, and Lord knows what other criminal complaints are going to be filed. I know I've talked to the chief at least 3 times, and I know the prosecutors had this case in his lap, or her lap, excuse me, for 4 months. This could go on forever, possibly forcing circuit court action for injunctive relief due to the violation of the health and zoning ordinances. Thanks, Judge, for letting me respond to that.
Mr. DePietro, I'm hesitant to enter an order for escrow where you say that your client is at least aware that there are these issues of someone residing in what is essentially a commercial property. So I'm not sure how to affix a rental rate for what is a garage space that from Mr. Chapman's argument, well, from Mr. Chapman's statements that he's using maybe as a repair shop. Mr. Chapman, were you saying something?
I was wanting to refute or challenge Attorney DePietro's statement.
This doesn't need to be a longer hearing. So on the narrow issue of escrow is where I'm trying to focus us right now, Mr. Chapman.
All right. Since there's no signed contractual agreement, the thing should just stay the way it is until I either ask the court to say, hey, I'm gone, And that's not that far off, Your Honor. We're looking at probably the end of March before I can get everything out. The snow's got to melt, and I've got to be able to clear the parking lot too. So in the meantime, I would ask you for an order against Gene Carrier next door to have no contact, because he's one of the problems here. He's the one who's spiking the locks. And we're finally getting around to a legal eviction. Any attempts to evict illegally, and I believe that should be a matter for the jury too. That's a finder of fact question. But as far as that goes, I'm going to request that jury trial, and however long it takes. And the escrow account, there's no basis for an escrow account. And as for using this place for a living space, they categorically have no proof. Like I said, there's no shower here, there's no toilet. It's just something they can't prove.
Mr. Chapman, at this point, what I will do is decline or deny Mr. DePietro's request for an escrow order for now.
Thank you, ma'am.
This matter will be adjourned. If the parties are available next Friday,
As in
February
10 days
26th,
next.
February 26th at 10 a.m.
Yes, Your Honor. Judge, may I present a witness at that time pertaining
Yes.
to the escrow order?
Yes,
Thank you.
because Mr. Chapman, when we come back on the 26th, the issue is going to be, is there a triable issue of fact that will require there to be a full-blown trial in this matter? This is a termination of tenancy case where the narrow issue will be, do you have a defense to the notice to quit that was served? Is there some defect or something incorrect with the pleadings that are currently on file with the court? This brief adjournment will also give the court an opportunity to provide Mr. DePietro a copy of what you filed with the court on February 10th. Well, we have a date stamped on February 11th, so that we're all on the same page as to any claims and any alleged offenses.
Thank you, Your Honor.
Your Honor, I think that my response that I refuted any material fact in the primary complaint should be enough.
I hear you, Mr. Chapman. And we
Thank
will
you,
address
ma'am.
that on the 26th. And again, I will have the court clerk provide a copy of your, thank you, Mr. DePietro. Provide
Judge, I forgot all about it.
I was gonna let it go, but if you hadn't disappeared, it would have been fine. I'll have the clerks provide a copy of your letter to Mr. DePietro, and next Friday at 10 a.m. If you want to give testimony, we'll swear you in. We'll talk about the testimony you want to present. Reasonable?
Your Honor, I'd also like to clear for the record, I have never used this address. My current address is a post office box, box 2665, Belleville 48112. And I would like all correspondence be directed to that post office box. I am not living at 259 Eastern River Drive. I haven't lived there in, 35 years. That is my parents' address.
Where do you
I
live,
am
sir?
not. Where do I live?
What is your physical
I'm
address?
I'm staying with a friend right now, and I'm not allowed to use that address. But as a mailing address, that's the address I'm going to use.
And that's the address that the court will use. That is the address that was on your letter to the court. Anything else?
Yes.
Afternoon, Mr. DePietro.
No, Your Honor. Thank you for the time.
Anything else, Mr. Chapman?
Thank you, Your Honor.
I'll see you next Friday.
Thanks, Judge.
Thank you.
Thanks,
you, Your Honor.
Judge.